including in UK and elsewhere. So there could be situations which may determine that one has to take a view depending on the local conditions. But from the point of view of competition law, I entirely agree that one has to have a delicate balance on the right to exploit the innovation and the public benefit.
While I think you've made an extremely valid point on the question of the socioeconomic reasoning, and even in the pharmaceutical sector, the thing that bothers me is this question of compulsory licensing. You see, whatever might be the question that the prices are very high, or you need it for the sake of going into the court and getting it, intellectual property is like any other property. There's a right to it. But what is important to remember is that there are other policy mechanisms which the government should use. You know, it's a question, the commission cannot be a redressal for every complaint when it does not necessarily emanate from a market condition. If that's an innovation that has to be given because you are signaling for more innovation, if that signaling is something that you have to protect, but that is equally required, which I'm taking the case of the pharmaceutical, for the country, perhaps there are other ways of addressing it, where it could be, you know, this direct benefit transfer. Even within the policies themselves, they have to find ways which doesn't distort. Because the classic example coming from the electricity sector is subsidy to the consumer distort the electricity market. You could, through the tariff, but if you give it to him directly, it has other benefits. So I think from the competition law, the competition policy, and all these debates, we have to start thinking. And the most important thing here is what are the signals we're sending out? And my own worry at times is that we are concerned that perhaps these dominant firms are not Indian. But in another year or two, we'll be the dominant firm. So it's, you know, it's that externality effect. And what is the signaling? That's one effect of signaling. The other signaling is what is the incentive that you give, which is what you have emphasized.
Just intervention was not by the competition regulator, it was by the other regulator, and there was a provision in their law for making that kind of intervention. So they acted according to the provisions of their law.
But I think we can talk about it because it's a very interesting point. Very, very interesting.
So on the fine balancing act, so to say, between protecting innovation and protecting the process of competition, and I think Ruchit pointed out rightly, there are several examples of where the Commission has got it right. The Commission has had several instances of cases being initiated and brought up before the Commission which involve an element of IPR. And I think ultimately it's a very nuanced and fine argument to be made, and it's a point where clearly there are heavy arguments on both sides about what is appropriate intervention and what is not appropriate intervention. My personal take on this issue is essentially it's rooted in the belief that there is a law that protects your intellectual property right. It gives you some level of exclusivity and protection. And if there is a question which relates directly to that right, perhaps intervention may not be appropriate. But if it's a question that relates to exercising of market power that comes to you as a result of that innovation, then perhaps intervention may be required. So market power flowing from IPR can perhaps give rise to appropriate cases for intervention under the competition law, but cases that relate directly to exercise of that intellectual property right. For instance, there was a whole discussion on compulsory licensing. There was a whole discussion that the concept of refusal to deal perhaps is appropriate. But there are clearly arguments that fall on both sides of the line. I'm guided by my understanding of what Section 3.5 provides for. It clearly recognizes intellectual property rights. It talks about the Commission's ability to look at the reasonableness of conditions that are imposed. But perhaps the conditions in question need to be first looked at. If those conditions relate directly to the IPR in itself, perhaps there is a question mark on the scope of intervention. But if the conditions relate to something that have that directly flow from market power, then I think intervention may be required.
Yes, sir. Good. I think there's clarity required. We are talking about signaling. What are the signals you send and through the commission, and what are the other modes of intervention?
Well, I only wanted to say here that we are fortunate to have Mr. Gopal Subramaniam, who represented CCI in the Supreme Court in the first ever case which went to Supreme Court when I was chairman CCI, and the Steel Authority of India case, the celebrated judgment which emanated out of it in September 2010. My only loss is that I would not be able to hear him. I have to leave at 5:30. But I am so happy that our young colleagues here, many students from National Law University and others, would be able to hear you on your take on that.
I fully agree with you, and that judgment is a path-breaking and very guiding, actually, guiding judgment. This has sorted out many initial teething problems. Otherwise, we would have been struggling in, doing commission's activities. And for that, credit goes to you, sir. Thank you. Now, with this, we come to the last discussion point, and in this, we have now come to a conclusion that during the discussion, we find that in the entire process, we have to protect the competition and not the competitors. The competitors have to become efficient, and we have to be innovative, and they have to struggle for to remaining in the competition, and for that, the competition process or competition has to be protected, not the competitors. And for that, I request Mr. Ravi Shekhar to give his opening remark. And along with it, the last discussion point also you can cover, because we are reaching to the closing time also. So combine it, that should be covered, the predatory pricing and the e-wallet issue also.
I won't take much time, because I think we've already
please be brief, so that we
we've
can have one or
on
two questions also at the end.
Sure.
And 5:30 we will have to close.
Sure, sir. So I think one thing's pretty clear. There will always be victims. So when you have innovators investing billions of dollars to come up with the next magic formula, so to say, there will always be victims. There will always be someone who falls on the wayside. There will always be companies that don't get it. Kodak, I think, was a great example that Sir quoted. And incidentally, Kodak was the company which actually came up with digital images. Before anybody else came up with digital images, it was Kodak which invented it. And they still fell on the wayside. Now the question really is, from a competition regulator's perspective, who are the victims that you're concerned about? Are you concerned about competitors falling on the wayside because they can't keep up with innovation, or because their business model has now suddenly been cast aside? And that relates to the discussion and the point which ma'am raised about the changing definition of consumers. Consumers know what they're doing. And that is something that I think all of us as practitioners, as regulators, need to be acutely aware of. Consumers make their choices. And if it's acceptable to them today, something else might come along which might make them go away. The success of the cab aggregators is a clear example. I mean, I'm sure a significant number of people sitting in this room are perhaps going to Uber it out once the event is over. And that's because they made a conscious choice that instead of the black and yellow that we're typically used to, Uber is just the most convenient thing to do. So there will always be victims, and therefore it's a question of identifying who those victims are and where an intervention is required. Competition law should perhaps never be used to protect competitors who fail on merits, because competition on innovation, competition on price, competition in as far as efficiency is concerned, those are the factors which should guide the analysis. And if competitors have fallen on the wayside, activating the mechanism of the CCI by those competitors and things going in for an investigation is perhaps a waste of resources. It's a waste of limited resources. If the victims are consumers, if the victim is the competitive fabric of that market, absolutely. there's no question about whether or not intervention should take place. Intervention will and should take place. But competitor-driven action, and we have become quite used to it. We know that several competing companies do adopt litigation as a competition strategy. But when it's competitor-driven, it may not always hold water. And my personal take on this has always been that the Competition Act, the regulations, the enforcement priorities should always be guided towards protecting competition and never competitors.
No, nothing to add to that.
Nothing. Okay, very good. Thank you. It's rightly pointed out that this competition commission or the competition law is not the dispute resolving mechanism available between the two competitors. It is the process and the market issues which has to be corrected. Would you like to make some comment? Okay, thank you. Thank you.
Just a word in the conclusion, I would only like to say that we have the young competition lawyers now coming up, taking the shape of, leading the shape of things to come. I hope in the end the Competition Law Bar Association would be able to help some of these young lawyers to really come up to the global standards.
We have decided to take only 2 questions. Thank you. Please go ahead.
Thank you very much, sir. I have a question for, I'm Parth Sarthi, I have a question for Dr. Geeta Gauri. There is a view in the market that, there is a view on textual... Sorry. Am I audible now?
Yeah.
Okay. So there is a view on Section 4 of the Competition Act, and there is a very textual interpretation given sometimes that if there is no effect, there has, the Act doesn't provide for any effect test, and therefore if there is a dominance and if it falls under any of the 4 categories, then you are supposed to, the CCI may hold you as abuse of dominance. Now, given what we just discussed today, that the purpose of the Act is to promote competition and to protect competition, and as Honorable Member Sri Mr. Bankar also clarified at the very beginning that yes, we will intervene when there is a distortion which is happening in the market. Given these 2 things, how much do you think this argument, the textual interpretation of Section 4, in the whole grand scheme of the Act, in that view, it really holds water?
Parthasarthi. Very good question. It's a very relevant point, and it has been discussed also. On the question that Section 4 has the word shall rather than may, and therefore it can become a total per se. And once whatever you do, you can prove dominance, then the abuse just follows. It's almost necessary. To that, I'd also like to add to it, which is very interesting. When you look at Section 19(4), they only have factors which decide dominance. I keep trying to look at that innovation or other factors. And Section 4 is ex post, which is where innovation matters. But we have innovation in 24, which is ex ante. And that is something which I've never understood, because it is with the question of looking at, when you look at the literature on monopolistic competition, that ex ante, ex post becomes very clear. But the Commission itself has debated this. There's been a discussion on it, and they've decided to go in looking at it in terms of effects outcome. The issue then becomes with the effects outcome is that as the Commission matures, there's better and better economic analysis that is coming. And I think to that extent, the idea that it is textual doesn't happen. And all my discussion now, also in the fact that a lot of the part of the Act would have to be modified and the arguments put together, is something the Commission will also develop and look at.
Sorry, am I audible?
Yes.
Yeah. Hi, my name is Archana. I just have 2 small observations to make, especially on what Mr. Patel said. When an IPR right is granted, the bargain that is struck with the brand owner or the IP owner is, I will grant you an exclusivity for a certain amount of time, But in the bargain, you need to make public the invention that is actually made. So as opposed to the fact that it is actually not made public, which is separately covered under confidential information, when an IPR is granted, the bargain is that the information is made public and which can further be used by competitors to make further inventions. That's the first. The second one being that when the question of interplay of competition and IPR comes into the picture, the commission probably needs to be a little mindful of the fact that when a question of IPR is called out, exclusivity comes with it. But the exclusivity comes with it which is granted under a statute. So while Mr. Nair pointed out that even when it's a question of market power, the commission may go into it, the commission also needs to be mindful of the fact that market power and the power to look into it is covered under different statutes under which that exclusivity is granted. So maybe the interplay there has to be worked out pretty well before the commission entertains an information.
Yeah, thank you. That's an interesting question. I'll let Ravi maybe answer the second part. On the first part, the bargain you described is a little partial because it really only refers to patents. You're talking about a patent being lodged with a patent authority and thereby making the invention publicly known. But innovation isn't just confined to patents. There are hundreds of innovations on your mobile phone probably, which are not patented innovations that require equal amounts of protection. And so the bargain isn't only in relation to patents, it's also a broader context. And if the idea should be in India, and this is a little Marxist, that innovations need to be publicly displayed such that after a period of time others can share, well, that I think would be hugely, hugely problematic. It would be like Coca-Cola revealing the secret sauce, or my mum's dal being told, the recipe to everyone. Those things, I think, are secrets for a reason. Those are competitive advantages that people want to retain and are the essence of the product.
You're talking about trade secrets and confidential information.
And copyrights and other things. So I think those are important things to protect as well as patents. So the bargain is, even if it's not quite the case of patents, the bargain is that innovators are allowed to reap the benefit of their innovations for a period of time. And if it were otherwise, people will not share. People won't do it because they'll go to another jurisdiction where they make better returns.
With this, we come to an end for this discussion. Thank you very much for listening patiently. I thank my panelists here and the organizer, CLBA, for giving this opportunity. And I think this is the topic which will be coming again and again for discussion, because this will need further clarity as and when the technology further gets advanced. Thank you very much for patience here.
Thank you, panelists, for the photograph. So now we have to start the next session. So the people from the first floor who are attending the other session are also coming down. So request all of you to stay here.
A big thank you to the speakers of this session, and a welcome back to those who are coming down from upstairs. We'll just wait for a few minutes before we begin the valedictory session, and I'll request you to take your seats and get set for that.